advisors in the office of the governor, 31 chief officers, yet the county has only 6 departments and 2 deputy county secretaries whose positions are not known to law. This has created an excessive wage bill that is 46% of the annual revenue allocation, far beyond the 35% limit set by Section 25, subsection 1, paragraph A and paragraph B of the Public Finance Management County Government Regulations 2015. 3. The governor has grossly violated Articles 10, paragraph 2, 73, Article 232, and Article 235 of the Constitution, and Sections 59, 59A, 60, and 62 of the County Governments Act 2012 by disregarding the criteria for the establishment of offices within the county public service, by illegally creating offices for advisors and deputy county secretaries without the involvement of the County Public Service Board. 4. The governor has grossly violated Articles 10, Clause 2, Article 185, and Article 201 of the Constitution by refusing to implement the recommendations and/or resolutions of the County Assembly requiring the governor to control and manage the county public debt in a manner that undermines the authority of the County Assembly, thus resulting in unmitigated accrual of debt to unmanageable levels. 5. The governor has grossly violated Articles 201, paragraph D and paragraph E of the Constitution by failing to utilize bursary funds in accordance with the approved budget, resulting in a discrepancy of Kenya shillings 30 million, which cannot be accounted for. Ground 2, abuse of office. That the governor has engaged in acts and omissions which singularly and collectively amount to abuse of office and gross violation of, among others, Article 201 and Article 232 of the Constitution, Sections 8, 9, 10, 11, 12, and 13(1) and 35 of the Leadership and Integrity Act 2012 by the following. A. Appointing 36 advisors in the office of the governor, contrary to the Salaries and Remuneration Commission Circular dated 29th July 2013, the Transition Authority Circular dated 6th September 2013, and subsequent guidelines from the Intergovernmental Relations Technical Committee, all of which limit the maximum of advisors to 3. B. Appointing 31 chief officers instead of 18, which are provided for in the County Executive Staff Establishment of July 2022, yet the county has only 6 departments. C. Appointing chief officers under 2-year contracts, thus creating a climate of fear and uncertainty which reduces public servants to be servants of the governor and not the people, contrary to Article 73, Clause 1B of the Constitution. The governor failed to renew the contracts of 31 chief officers and instead directed them to hand over to county executive committee members, significantly affecting the continuity of service delivery in the county. And D. Appointing 2 deputy county secretaries, which positions are not known to law and are not in the county staff establishment. Ground 3, gross misconduct. The governor has grossly violated 1. Articles 10, Clause 2, Article 27, Article 28, Article 73, Article 75, and Article 232 of the Constitution, and 2. Sections 3, 7, 8, 9, 11, 34, and 52 of the Leadership and Integrity Act. 3. Sections 9, 10, and 21, subsection 2 of the Public Officer Ethics Act 2003. 4. Sections 2, Section 30, subsection 2, and Section 30, subsection 3 of the County Governments Act by engaging in acts which singularly and collectively amount to gross misconduct by the following: A, making disrespectful, sexist, and demeaning statements against Senator Fatuma Adan Dulo publicly that are only meant to denigrate and degrade her as a woman leader, thus violating her right to dignity. The governor's utterances do not demonstrate respect for the people and other public officers, nor do they bring honor, dignity, or maintain public confidence in the office he holds. The governor's statements amount to gender-based psychological violence and undermine the dignity and the integrity of the governor's office. B, breaching public trust by making divisive, derogative, and discriminatory remarks against other clans residing in the county, thus undermining public confidence in the integrity of his office and sowing discord in the community. And C, being continuously absent from the county and running its affairs remotely from Nairobi, thus stalling service delivery. Honorable Abdi Ibrahim Hassan, how do you plead to the three grounds? Ground 1, guilty or not guilty?
I plead not guilty.
Ground 2, guilty or not guilty?
I plead not guilty.
Ground 3, guilty or not guilty?
I plead not guilty.
Next order, clerk.
Order number 3, hearing and determination on the proposed removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County.
Now, honorable senators and the parties to these impeachment proceedings, before we embark on the main hearing, Rules 14 of the Rules of Procedure demands that if there are any preliminary issues be raised at this juncture. So if there is any party that has any preliminary issue, this is the moment to raise it.
The Honorable Speaker and the Honorable members of the Senate, we had given an indication to the Honorable Senate that we intend to raise 2 preliminary issues for the consideration of the Senate, and the issue, Honorable Speaker, is contained in Volume 1 of the document that we filed. In response, we filed several documents, but Volume 1 contains the preliminary issue that we intend to raise. Honorable Speaker, with your leave, I can then quickly delve into that question. The Honorable Speaker, we had noted from the order of proceedings that was supplied by the Senate that this session would take about 1 hour. I propose 2 hours, with 1 hour on our side. I propose to take about 30 minutes or less introducing the first limb of the preliminary issue we intend to raise. Thereafter, my colleague Elisha Ngoya will take 20 minutes, and I will reserve 10 minutes for any rejoinders which will be handled by our colleague, Mr. Elias Mutuma. Mr. Speaker, sir, and honorable members of the Senate, with your permission, we would then move to raise the preliminary question.
So what you're saying is you require 1 hour to effectively move your preliminary issue?
Yes, Mr. Speaker, sir.
Okay. I'll grant you 1 hour, and also I'll grant the County Assembly 1 hour to respond to your preliminary issues. You may proceed, and time starts running from now.
Thank you, Mr. Speaker, sir. The Honorable Speaker and honorable members of the Senate, on the 26th of June 2025, the Speaker of the Isiolo County Assembly issued a press communication at around 3 p.m. announcing that the County Assembly had resolved to impeach the Honorable Abdi Ibrahim Hassan, Governor of the Isiolo County. This communication will be found in Bundle 3 of our volume, that is Volume 3, at pages 2, 3, 4, and 5. This release is significant in these proceedings as it marks, in our view, the announcement of a phantom impeachment of the governor, and we will shortly demonstrate the salient gaps and schemes, and hopefully persuade the Senate to reject this phantom impeachment. The Honorable Speaker and honorable senators, the press release by the Speaker of the Isiolo County government triggers a very important question, and that is the question upon which our first limb of the preliminary objection stands. What is in law a resolution of the County Assembly? The Isiolo County Assembly Standing Orders, and specifically Standing Order 65-8, provides that when a motion for the removal of the governor is passed by at least 2/3 of all the members of the Assembly, the Speaker shall inform the Speaker of the Senate of that resolution within 2 days. You will find this resolution from the Assembly in the Assembly's volume, that is Volume 3, at pages 100. So, Honorable Speaker and honorable members of the Senate, it is our submission that for the power of the Senate to be invoked under Standing Order 80, the Speaker of the Senate must receive a resolution from the Speaker of the County of Assembly. So therefore, there is a test that is twofold. The first test is that there is a resolution, and the next is that it is supported by 2/3 of the members of the Assembly. Honorable Speaker and honorable members of the Senate, in forwarding this resolution, the Senate standing orders, the third schedule of the standing orders, and the Senate's guide manual on the procedure and rules for removal of county governments developed in 2025 require certain documents to be submitted together with the resolution. And that is the impeachment motion, the county assembly Hansard, the division of voters list, the advertisement of the summons to the governor, the list of witnesses of advocates, the list of advocates, list of witnesses, records and videos, and other evidence. It is our submission that this has a very good purpose. This requirement has a good purpose, and it now fits into the preliminary objection that, or the preliminary issue that we raised. Honorable Speaker and the honorable senators, I will then invite you to examine the documents that were presented alongside the resolution from the Speaker of the Isiolo County Assembly in support of the fact that there was a resolution adopted by the Assembly to remove the governor. I will refer the Senate to the Assembly documents, and that is at volume 3 of the Assembly documents, that pages 1 to 6, which has the order paper for the 18th, and that order paper ultimately indicates that the motion for the removal of the governor was adjourned to Thursday, the 26th of June, 2025 at 2:30. That time is extremely material to these proceedings. The Hansard for the 18th of June, 2025 at pages 7 to 14, that is still volume 3 of the Assembly documents, indicates that the proceedings for removal of the governor were also adjourned to 26th of June, 2025 at 2:30. At pages 15 and 16, that is still of volume 3, there is an invitation to the governor to attend. That invitation invites the governor to attend the Assembly on the 26th at 9 a.m. Honorable Speaker, volume 5 of the Assembly's documents at pages 3 and 4 contains the affidavit of service of that invitation served by the Speaker. So there is no doubt whatsoever that the governor is invited to appear at 9 a.m. on the 26th. The Speaker, in volume 5, also presents a document for the special sitting of the Assembly. It is dated 23rd of June, 2025, and that sitting is indicated to commence at 9 a.m. Honorable Speakers and honorable senators, it is therefore not in any doubt that the Assembly set the hearing of the motion for the at 9 a.m. 26th of June. I now refer the Honorable Senate to the Isiolo standing orders, specifically standing order number 1. It is found at volume 3, pages 85 and 86, on the times set for the sitting of the Assembly, and that is 9 a.m. for Wednesdays and 2:30 for Tuesdays, Wednesdays, and Thursdays. I do not need to say this because you're familiar with these times. It therefore follows that if the Assembly is to meet at any other time other than as set out in the standing orders, there must be a resolution to that effect. And so, therefore, the logical question that we are asking the Senate is this: is the Hansard genuine? Because the Hansard talks about a sitting conducted at 2:30 p.m. That is in line with the standing orders. But the notices, the invitation, and the special sitting issued by the Speaker talk about a sitting to be conducted at 9 a.m. So therefore, Honorable Speaker and Honorable Senators, we invite you, the Senate, to take note of the above, and then allow us to also review the Hansard that is provided. You probably understand the Hansard much better than we do, and I refer you to the Hansard for the 18th of June 2025, which clearly shows that the Assembly was adjourned to 26th of June at 2:30 p.m., and I refer you to volume 3 still of the Assembly's documentation. The issues that you will note when you review the answer is that, first of all, it is not certified by the clerk as is required. It just bears a stamp. It is therefore our submission that these latent, open, obvious, and blatant contradictions and anomalies between the Hansard and other records provided by the Assembly are major indicators not only of misrepresentation, but that the documents presented by the Assembly have been cooked and generated outside of the Assembly. This is further supported by the testimonies of the witnesses, which will be found at volume 2 of the Governor's response at page 14, where we have the affidavit of Salad Boru Gurasha, who was the clerk of the Assembly, who confirms that there was no sitting of the Assembly on either date. There is an affidavit by the Leader of Majority, Diba Ali, at pages 41 to pages 45, who confirms there was no sitting of the House Business Committee to deliberate and set out the order papers. Further, we have the affidavit of Shaban Mzungu, who was in charge of security at the Assembly on that particular day, and he confirms that there was no sitting of the Assembly. Honorable Speakers and Honorable Senators, we expect that the Assembly will try to persuade you that the issues we raise are not preliminary and they require a full evidential hearing. But allow me, Honorable Speaker and Honorable Members of the Senate, to refer you to the Assembly's submissions on the preliminary objection, because they have filed submissions on the preliminary objection and they have quoted a decision. And the jurisprudence from the courts is that a preliminary question is determined on the presumption that the facts pleaded are true. The facts that we are raising are the facts that have been pleaded by the Assembly. And that preliminary issue, when determined, may as well as dispose of the suit, and it is for that reason that we raise it as a preliminary issue, because if this Honorable House was to find that there was no sitting of the Assembly, then we cannot proceed with the hearing of the impeachment motion. And so we submit that these questions that we have raised satisfy this threshold, and we invite the Senate to look at the facts that have been pleaded by the Assembly and the documents that have been provided, and agree with us that this is a case of a phantom impeachment. Finally, as I, with one eye on the clock, we submit that this process is a hallowed process. It is not just about whether the grounds set out in Article 181 of the Constitution have been met. If the Senate is to examine whether there was a valid resolution and agree with us that the documents that have been presented are forged and cooked, then this impeachment, this phantom impeachment, amounts to an affront on the Constitution, and it sets a very dangerous precedent, because what it means is that it is possible for the Speaker and a few members of a rogue assembly to, in a way, attempt a coup, sit somewhere, cook documents, and present it to the Senate, and the Senate will then hear that matter. That in itself will be a violation of the Constitution, because this Senate has a mandate to protect devolution and to protect the counties. And that is the danger that we face in these phantom impeachment proceedings. Honorable Senators, the impeachment proceedings not only put the governor on trial, it does the same for the Constitution. It does the same for the Senate, for the members of the County Assembly, for the witnesses, for the lawyers on either side, and ultimately, the Kenyan people. It is our humble submission that the Kenyan people vested the power of impeachment in the Senate because they expected that the senators had special qualities, numbers, and temperament to rise to the occasion, and we urge this House to rise to that occasion. Finally, before I cede ground to my fellow counsel, allow me, Honorable Speaker and Honorable Senators, to just remind you of the words of Alexander Hamilton, one of the founders of the American Constitution, on the power and the question of impeachment. Hamilton explained that the senators were seen as the ideal arbiters in an impeachment process because the Senate would be a tribunal sufficiently dignified and sufficiently independent of the actual interest aligned in the subject of an impeachment. We urge this House to rise to this occasion, and we respectfully urge the Senate to review the material that we have provided and to find that there was no sitting of the Assembly that gave rise to the resolution that is before you for consideration. And Honorable Speaker and the Honorable Senators, I thank you for the opportunity you have accorded us to address you on this issue, and I invite my senior Elisha Ongoya to take us on the second limb of our preliminary issue.
Thank you so much, Mr. Speaker, and thank you, distinguished senators. As indicated, my name is Elisha Ngoya, lead counsel for the governor. Before I address you on another substantive preliminary question on an existing court order touching on these matters, allow me to invite my learned colleague, Mr. Elias Mutuma, to wind up on that issue of the proceedings before the Assembly by drawing your attention to certain salient material aspects of the purported Hansards that have been presented before you, so that you have all that in consideration. Then I'll move to the next subject. Thank you so much, Mr. Speaker.
Thank you, Mr. Speaker, sir, honorable senators, for the opportunity. The council representing the County Assembly will be here shortly to try and convince you that what we have raised is not a preliminary objection, but requires an interrogation by way of listening to witnesses and making a determination based on what they will say. But our submission is simple, honorable senators, that what we have raised is a pure PO that can be addressed and determined based on what has been presented by the County Assembly of Isiolo. Honorable senators, my understanding of Hansard's records is that they are a verbatim record of what transpires in a House proceedings. Therefore, they are able to tell us exactly what happened on the day that that motion is said to have been passed. We have raised an issue with proceedings that are said to have taken place on the 18th of June 2025 and proceedings that are said to have taken place on 26th of June 2025. Honorable senators, with your kind permission, kindly hold your volume 3 of the County Assembly's documents. I will take a very short time to take you through the Hansards. And this being a house that is also a house that is very much familiar with proceedings in the House, you'll be able to tell me whether there is anything that took place there. At page 7 of that bundle, we have been presented with what is said to be the proceedings of 18th of June 2025. Page 7 of 7 of volume 3 of the documents. Page 7.